use the chat or Q&A tool in the bottom panel there, and he'll happily answer these questions. Alternatively, if there's something you don't wish to raise in an open forum, you will see Mohammed's details there on the screen and in several places during the presentation. mohammed.hack@fletcherday.co.uk. He will always be happy to answer any specific queries for you. Okay, Mo, over to you.
Thank you, Julie. Thanks very much, and very good evening to the participants. Maybe that is not an evening, because I see people are joining this webinar earlier on civil law and this now Fletcher Day from all over the world. So whatever the time zone is, good morning, good afternoon, good evening. Now, as Julie said, this is a new series, and this is about changes in construction contract. If you are someone whose day job is or involve construction contract, you must be, or even a student, you must be very, very much familiar with changes in one form or other. Any forms of construction contract, experience them. One of the reasons could be that it's not like goods you go and buy off the shelf. It's a service contract, and it's not like a service contract of going to a restaurant and buy some food, order them to be cooked to your sort of choice, and then served, eating and going out. It continues for a while. Also, the fact remains that in many cases, at the time the contract is entered into, many decisions, vital decisions about the contract and its respective obligations of the employer and the connected specifications for goods and materials, as well as finished product, or the built space is not yet been ascertained. It could be that the employer hasn't made up their mind yet as to what they really want. And then sometimes there are changes in law, and almost every time you'll find that there are some changes in law, and that's something, a change, a hidden one, or sometimes people don't even understand that that's a change of law, but that it is, and when we'll go in detail, we'll show them as well. So that's, I mean, the vitality cannot be of change, the importance of change in a construction contract and impacts that bring in to any construction contract doesn't need to be explained or overemphasized ever, because it's like almost a certainty that you'll have changes in a construction contract, and you got to deal with them. And how the model forms, not the bespoke ones, the ordinary model forms are doing it, what the related laws, how do you value a change that is the price impact, sometimes as I call it, and how there are other impacts which doesn't kind of impact it on the value, but obviously the first thing comes is time. It changes the dimension and the outcome of the contract and the respective obligations of the parties. We need to not only know, everyone has to be crystal clear in their mind, and also have the necessary operational knowledge and tools in their hand to actually conduct themselves on a day-to-day basis, to have the contracts completed and have less disputes. So as I said, everyone of us know how important it is, and we will run a series. My initial plan is to go for 12 kind of parts, if not less, 12, around 12. And so we're starting this in September 2021, and we do not do on December's and August. So that means we'll be running up to more or less the 12 parts up to the end of 2022. So it's going to be a long journey, and I don't have any rush. And what I want is, if you are with me and or will be with me, or at least watching them on the YouTube channel, you'll be working around your way and developing a sound base so that you can use it for future time. By all means, if you need my assistance at any point, either on payment or non-payment, feel free to talk to me and email me. And I'm always interested to sort of, I mean, the problem is that I'm doing it online nowadays. So it can't be like both way communication at the time of presenting the seminars. It would be different, because if we start then sometime later on face to face as well, it will be different for sure. But for the time being, this is the mode. So the only way we can communicate further is through email. So do feel free always to come back to me, and it helps me to go back and read again, because I've read these things years ago, although I practice them on a daily basis. So it gives me an excuse, so to say, to go back to the books. So any question, any query off and on during the seminar or later on is very welcome. And as I say, today is the first of the series of a 12-part. I will try to capture, this is like an introduction to the whole concept I'm trying to deal with, and I'll try to capture the basics first, and possibly if you are an advanced student, if you know what I'm talking about, this much is a kind of a wastage maybe, but eventually I felt it's always good to start from the beginning whenever you are starting or restarting, so to say. So because my title is Changes in Construction Contract, so I asked myself that, do I know what a contract is, and why some contracts are called a construction contract? So I've asked myself this question, and I've gone to various sources to find out an answer to it. And I did find an answer to it, that a contract is mostly, again, there might be exceptions, mostly a two-party, bi-party relationship where one party seeks to achieve or receive some services or some goods, and the other party delivers them for a price. That's a working model. I'm not saying that's a legal definition. And obviously, from a legal perspective, an agreement as defined by law or identifiable through the technique of offer and acceptance law of the respective jurisdiction is a common requirement. And an agreement makes it a contract if you have two more requirements. One is, of course, an intention to create legal relationship, meaning if the parties fail to perform their respective obligations, the other party, let's call him the aggrieved party, can then go to court of law and seek some remedies. It's not always the specific performance of the or correct performance. It could be seek some other remedy, which is more common, that's damage. So that's more or less is three requirements. And of course, there is a fourth one, vitally important throughout the Commonwealth countries. I'm not an expert in civil law. That's that, as we call it, a consideration. Well, we don't call it a price all the time because the person who is providing the service, his consideration, of course, is to get some return in the form of, most likely in the form of prices or a sum of money, and the person who's seeking the service or the goods wants the service or the goods he or she is looking for. So his consideration for paying the money, the price or the sum which he needs to pay is, of course, the expectation that the service is going to be provided as per the obligations defined within a contract. So that's said about what is a contract. Then the next question comes, what is a construction contract? Now, that's something confused somewhat in a confused state in England and Wales, where there is an act called Housing Grant Construction Regeneration Act 1996. We have a wide range of contracts that has been defined as construction contracts under this act. So in England, a construction contract may be a construction contract for the purpose of HGCRA 1996, or a construction contract which is, although a construction contract, but not a construction contract for the purposes of HGCRA 1996. So there could be a construction contract under this act, construction contracts not under this act. And under this act, it is defined that a construction contract is a contract to provide construction operations. And construction operations then is defined within the act, involving the services to build any works, any built space, and which would include, obviously, not only buildings, any structure, anything that forms part of the land, which of course may mean a wall, may mean a drain, may mean a tunnel, may mean simply some earthwork, digging the earth and throwing it somewhere else, maybe a retaining wall, maybe a bridge, maybe a road, all sorts of different types of construction operations are all included, which are forming part of it. And then, of course, those who are supplying the drawings, the design, the mechanical or the electrical engineering services and other engineering services, architects, all are the contracts which expect one of the parties to provide this service, all are included within this HGCRA 1996. Now, after stating what is included, the HGCRA also say what is excluded. So there are certain construction contracts, although by nature and definition they are construction contracts, but they're just excluded from the act. However, they still may be a construction contract for other purposes. So again, say for instance, building a nuclear power plant is not a construction contract. Interestingly, for example, building a ship is entered through or done just as a construction contract. So not necessarily a construction contract will bring under the belt only the buildings. Only actually there are statistics which say that only 2% of all construction contracts are buildings, and less so residential buildings. 98% are other than buildings. And obviously that includes roads, the bridges, the ships, the manufacturing units, and complex manufacturing units made of metal works and all these things, So that's all about in England and other places. I don't know much. And we should keep another thing in mind when we are talking about construction contract, is there is something called model contracts in construction. Now, when I was an undergraduate law student back in 1990, from the last century, of course, I have literally read in textbooks, very leading authors have said that model contracts are a recent phenomenon. They try to gather all the common terms and used in a particular trade or a particular type of contracts, and then they are normally endorsed by the guilds and the trade societies and used. Sometimes the employers and the government employers, they use it as well. Sometimes they're called as templated contracts, boilerplate contracts, whatnot. And so it's a recent thing that something is written like that in leading books. A couple of years ago, I was attending a talk by an ex-Court of Appeal judge from England, and he cited that a model construction contract was, or existence of a model construction contract was found in Assyria, Babylon, which must be 5,000 years ago. And more or less, there were similar terms which we use nowadays. So it's nothing new. Obviously, I mean, it's understandable because 4,000 or 5,000 years ago, people have built, or 3,000 years ago, people have built Parthenon, people built the pyramids, people built the Hanging Garden of Babylon. So they must have had some kind of contract forms common, and those were the model contracts. And then obviously the models are followed by the bespoke, because in this world there are people like me who thinks I'm just as ordinary as anyone else. So I'll just be trendy and follow the fashion. When it's teddy for me. When it's stripe and stripe for me. When it's bell bottom, it's bell bottom for me. I'm not of that kind that I have a style of my own, a signature of my own. So, I can just pick up any model that's in practice and follow it. But of course, not many people are like me. Most of them are very intelligent, very stylish, and they love to create something bespoke. Like every teenage young lover, that this is the first time this happened on Earth. So they will create a model, and they will not follow the patterns of Romeo and Juliet or whatever other things or couples are there in history. So what they do, they think, oh, we're going to make a contract of our own because that will suit our proper purpose. That the story will be, the characters will be our own, and the plot will be our own, and it will be reflected in our own manner. But they end up, as some researchers said in different articles, that borrowing from different model contracts and creates something like an Italian marriage day soup, meaning that picking up from everywhere and then boiling it together and making an absolute mess. But well, I don't dare to say this. I respect them a lot, although I prefer not to work for bespokes. I mostly work for models. But if someone is thinking like that, then so be it, that's their choice. But you have to keep in mind that there are models, there are bespokes, but obviously, even if something is bespoke, this is the end of the day a construction contract, so they will be addressing the similar things, and the same issues have been defined in the models. Now, the parties, of course, are the employer or the client who's ultimately wanted to have a built space or a built structure, and they're called sometimes the employer, sometimes the client. Sometimes the employer is in contract, the client may not be. They might give someone else the duty to enter into the contract. So all sorts of varieties are possible, but client or employer is the entity or the person who owns the project, under which a contract has been agreed. Then, of course, the contractor, and if you are at least in the UK construction industry, you will know that there is a variety of contractors. There are framework contractors. They do not do much. They're the partners to the bigger projects, and they ensure that the contracts are rightly entered into, and they have loads of suppliers and other things. So they enter into a contract with the main contractor, ensuring that the goods and services that are supposed to be delivered are delivered at the right level of quality by their framework listed contractors. And then, of course, after the main contractor, again, the main contractor actually doesn't do much or construct their own on their own. What they do is they're again a management type body. They employ the subcontractors. Then, of course, the subcontractors then employ the different trades, and then the trades then employ individuals. So the trade contractors then individuals, and then that's how it's done. So every single project for every single package of works may have more than one contract. And the employer will definitely have a contract with the professionals. And then in the modern times, sometimes these professionals are transferred to the contractor. And then the contractors will have contracts with the professionals. And as well as the employer will have contract with the contractor or the framework contractor. And then the main contractor comes into picture, and the subcontractor. So there is a contract between the subcontractor and the main contractor. And then it goes downwards. So every project will have many, many layers, vertical layers of contracts, and all of them will be, and horizontal as well, and all of them will be classified as a construction contract. Now, how is it made? Well, I mean, there isn't at the time we are talking in English law, and there has not been in English law. I think there is a case in the 19th century, Van and Vernus, which first stated it categorically that English contract law does not require any form, meaning that it's fine that you verbally agree a contract. I will come back to this issue time and again, but throughout my presentation today and later on, because it's very vital that you spot your contract. When has it happened? When actually the offer was accepted and there was a consideration which was discussed. In a later case, on a later presentation, on a different webinar, I will discuss it more in detail of the essentials of construction contract, and because that has an impact over changes as well. But suffice it for today to remember that it could be wholly in writing, it could be totally oral, and it could be a hybrid, part oral, part writing. It could be done in orally and then evidenced in writing. It could be done through deed. And to be honest, of late, this through deed contracts are getting more and more popular, and that brings occasionally some problems as well to change the contract. So we'll see them again as and when it comes. But for today, that's good enough. Next slide. I've discussed about model forms, that these forms are over centuries developed through the common interest groups who are doing similar sorts of things regularly. and then endorsed by themselves, and then used by them. And of course, they've been borrowed by the bespoke makers. And also, many a times, what happens, you go to a solicitor and say, I'm going to go to this contract, ICE, or my tender requirement is I have to go through a London Underground model form, or a react and maintenance contract under one of the such and such, water authority in South or Thames Water. And they said, that's fair enough, but I'm an expert on this, and I'm going to give you some suggestion. You shouldn't sign on this, sign on that. Look, and then they create a list of amendments of 100-page, which is maybe the main contract is 95 pages or 75 pages. So that's how, although it's a model contract, still called as an ICE contract or a LAL contract and react and maintenance contract, it essentially becomes a bespoke. And that creates another difficulty, because when you go on site and start administering it, you'll see that it's creating more problem than a solution. Because if you are following a model as is, knowing your limitations there, what risks you are taking on, these are well defined because they're in there for ages and they've been tested in court of law, defined and interpreted time to time by the highest courts of different lands. So we know what every single sentence in the word means. But then if you start touching it, thinking that I'm a great expert and I can do that, mind you, every set of suits have been developed by hundreds of people together. All of them are leading professionals in their respective fields. So it's not so easy. Just because you don't understand it or I don't understand it doesn't mean that it's not doing the right thing. The more important thing is what you understand you are taking, what obligation you understand you're taking on your shoulder. And are you providing sufficiently for the risk you are taking? If you keep those in your mind, be you an employer or a contractor, it doesn't really matter much which one you are dealing with. And we will see there is a popular streetwise belief. There are some reasons for that as well. I will not sort of say that it's not wholly true, but there are, end of the day, we are dealing with similar things. So it doesn't matter whether it's ICE, NEC, JCT, IKMA, Network Rail, LAL, reactor maintenance, whatever we are calling them. End of the day, we're dealing, or even the FIDIC models, it's more or less the same thing. Now, first one model in UK is been in place for ages, was ICE by Institute of Civil Engineers. And they had I think one of the models were created about 100 years ago. And they've sat together and they've decided to create a common form in use. But then this new engineering contract suits, which came in 1990s, kind of took over from ICE. The main difference is that NEC incorporates a working management model. Okay, the whole idea is that we are nowadays involved in corporate world, and the contractors and the subcontractors, all are companies. They try to manage it from a distance, not only just go do build and come back type scenario. They want to sit back, budget things, allocate things, supervise things, ensure that the quality is maintained from a distance. So this is more of a management approach, and increasingly it was felt that that's actually a necessity, and if another thing must be said that worked, a good friend of mine, Martin Burns, I will actually quote him later on today. who was one of the members who were involved in creating the NEC suits. You might have seen, some of you might have seen him. We present CAP conflict avoidance pledge seminars together. He's at the RICS, and he always advocates this, that this is a contract where we wanted to go on a collaborative approach rather than a fighting approach, which is sometimes, you know, a scenario that comes into play in mind if we talk about construction contract. That's the historical scene. It's something like a fight, you know, on site, and bullying and all these. But no, this is a different sort of idea, that let's try to collaborate. And how wonderfully they have introduced it, I'm not too sure. Another, actually, a student of mine, I used to teach the RICS matrix for Silver Shemmings at that time it was, and a person called, I think it's Meena Chowdhury, he used to attend many of my sessions, and he's, I think now he's the director in the HS2. He was there at that time, was in Crossrail, and all these contracts are modeled on NEC, and he named NEC as a never-ending contract. So in other words, he was thinking that it's not, there isn't any certainty because it's very open-ended. But anyway, everyone has their own choice to make a comment. But I would say it is the contract that's taking more and more share of the market, and it's going to be the next generation contract for all material purposes. Having said that, interestingly, ICE has actually archived their contracts initially, but then they've come back with a new name called ICC conditions from 2011. Because, and I have worked on ICE models back in 1990s elsewhere, not in England, in Asia. And funny enough, that when I've come back to England and everyone said, you know, this is a wastage of time, you worked on FIDIC and ICE, it's no more in practice in England. And then I found in a huge project I was involved in for the earthwork contractor back in 2013, 14, if I'm not wrong. They based themselves on ICE because of the simplicity of the conditions, and they didn't want that kind of a sophisticated, an international partner was involved, so they just wanted a simple form of contract, giving them the opportunity to get it done type, you know, it's like something like Tesco value type. I had the opportunity to talk to the employer as well, because I was working for the contractor, and some of the professionals at the employer asked, you know, why do you go to ICE? You know, this is no more in practice in England, and this is a project around London, and why you are doing that? And they said, look, I mean, we just wanted to be simple, you know. And I would also ask everyone to remember that the something that's called CECA. Normally we say CECA, okay? CECA is CECA, which is the association of civil contractors, okay, in the country, in England. And that association publishes rates, and they used to publish it in collaboration with ICE, and NEC still uses CECA rates, and they're wonderful rates. They are not only wonderful rates, there are good reasons to use them, because they are very kind of detailed. For instance, they if you are pricing an equipment, CECA will ask you to bear in mind the cost of the operative, the cost of transportation, the cost to the site and back, the cost of protection, the cost of fuel, and all these. Now, even a month ago, somebody asked me that there was an equipment list added to an NEC contract, and there was a downtime. And the question came, how do we value the downtime of the equipments, and the agreement was that we use Seeker. And how do we employ this? Because there was a downtime, there was no fuel involved, there was no operative involved. You know, because Seeker is so detailed, you can just then deduct it. So you know the benchmark, where to start, and then you know how to relate it to the actual thing. So when you go to this sort of valuation issues, that will come later on, of course, we're running for 12 parts here, we'll see that although ICE is dead now and ICC has taken its place but not been used that much in UK, but still Seeker remains important. And if I'm sure many of you know it very well, but if you are not, this is the world of Google. Just go and Google them and you'll find even the older rate's been archived, so you can have a look, even though you do not need to follow the particular value of a rate, but the components are very important. And if you are actually doing an NEC or even doing a variation evaluation in JCT, it's a good point to consider, you know, what are the elements I'm going to take or not take. Now, there are other bodies like JCT. JCT has been, again, a very old contract. Back in 1930s, the Joint Contract Tribunal was commissioned. Initially, they were with the initiative of RIBA, the Royal Institute of British Architects, and the members were, of course, the Federation of Builders, National Federation of Builders, contract groups of different sorts, and of course RIBA were there. So they all joined together to produce a model form. As I was saying, you know, I dare not to be a stylish person compared to something like a model created by JCT. But I was occasionally part of model contract drafting, not in England, in other jurisdiction. And I know the type of people they're involved, you know, how experienced they are and how many different groups to represent their interests are joined together to produce one. So I never would like to be a very stylish person and have a bespoke of my own. So joint JCT is like almost 100-year-old form. And we are running with a new version from 2017. Now, based on these, well, IChemE is Institute of Chemical Engineers. And if you are involved in your water industry, the foul waters and other things, construction of drains and things, subsurface culverts, the IChemE model is pretty much regular in use there as well. So although you might say, hang on a minute, this is a chemical contract and we're talking about construction contracts. Now, in particular sectors, same goes for highway thing. And London Underground has their own model form, and React and Maintenance is actually a creation on the line of NEC after an act which said the repair and maintenance in the water industry, utility industry should be react and maintain. It's a slightly different statutory regime, and that has prompted us. Now, having explained all these, by all means, as I said, I have experience in dealing with each of them, including FIDIC. If you have any particular question about any one of the models, in fact, someone was considering me to be a permanent lecturer in network rail contracts as well. Don't know. I'll ask Julie later on what happened to that. I did work on many projects in React and maintenance contracts for utility companies, but by all means, if you have any question, feel free to ask me through an email. But in the lecture itself, and that includes FIDIC as well, and in the lecture itself, I will concentrate on JCT and NEC. So obviously, we're not going to go and discuss the history. We are in 2021, and NEC suits 2021 is the NEC 4. JCT contract suit for current day in application is, of course, the 2017 edition. So that's what we'll take into consideration. And as I said, we will be discussing the change or how changes are dealt with under these contracts. So we got to understand first, what is a change in a construction contract? Okay, and is there a definition of it? You know, and we will of course focus it time and again when we'll be dealing with individual provisions of individual contracts. The reason I brought in here is the suit. Two different suits have two different group of contracts, of course. For instance, if I go to NEC, let me just keep my notes open. If I go to NEC, I say there are A, B, C, D, E, F. So how many? 6 different types of contract in the NEC suit. Well, I mean, there might be others. I mean, I'm going to consider not even the 6th, the 5-1, A, B, C, D, E. I'll take them into consideration when we're dealing, unless there's a specific question from one of the audience. So what's A and B? A and B are priced contracts, okay? Meaning that a lump sum figure is entered or proposed by the contractor to provide all the services and then that lump sum remains as the starting point. Of course, if there is a change, that lump sum needs to be adjusted, but there will be a lump sum. Now, why there is A and B? Well, the one is for an activity schedule, the other is for a bill of quantity. And why is it so important to distinguish between activity schedule and bill of quantity? Well, bill of quantity is a standard document. Those of you who are not familiar with the quantity surveying side of construction contract, for them, let me tell you that there is a thing called rules of measurement. Okay, rules of measurement. Earlier, we used to call it standard measurement, something like that, SMM. Now, it is standard method of measurement. Yes, that's it. And I think the latest version was SMM 7. Okay, I'll come to a minute what that means. But this has been changed, and now we have, in place of SMM, we have NRM. NRM is a new rule of measurement. Okay, now what's that? You know, what's the implication? Why do we have to have a rules of measurement? So historically, in engineering contracts, and this is for buildings. Okay, there are other types of rules of measurement for other types of contracts, engineering contracts. For instance, if it's a civil engineering contract, a CESM is used. If it's a roads engineering contract, then highway transport bill is used. So for each type of different contracts, engineering contracts, building or engineering contracts, you have different sets of rules of measurement. And what's the implication, or what's the importance of having a rules of measurement? Because what it does, it defines different works in a particular manner, which they believe is the easiest or more detailed for pricing purposes. Okay, so in other words, what has been done is, for instance, you think of a building, what has been done is, from right down at the bottom, the subsurface, to the roof, all the activities have been classified from A, classification A, to, let's say, O, okay, the English letter O. And each package or layer of work is assigned under one head. and then that's been sub-defined, okay? So, and subcategories have been included. So if you want to define the scope of the contract, primarily what you do is you pick up that list and say, okay, I want this type of a foundation or piling or underpinning or this, that, the other, okay? And then you throw it back to the contractor for pricing. Now, historically, legally, you cannot tender a building contract in this country till you have reached the point from a design perspective, that from the design, a contractor can tell what the ultimate quantities that's going to be needed to build a particular activity or a particular element of the build, okay, or the works. So you are building, let's say, a wall. Let's take a simplest example. So still you need to go underneath and put some foundation in. So there is an earthwork involved. You have to cut things out and you have to throw them somewhere or bring them back, some of it. So, and then you have, let's say, let's call it the simplest, a brick building with mortar joints. So you need the mortar joints, the building bricks, and then maybe a render of some sort, and then painting and other finishing and decorations. So, and it may be that you need some lightings on that as well. So what you do, you go to SMM, or now called NRM, you see that this is it, and you subdivide it, and you ask for a price for that. Now, historically, it was the schemes were tendered by the architects on behalf of the employers. I'm just trying to keep things simple under building contracts only for the time being. And they used to, it was their obligation to produce the bill. And so if there is a quantity miss, okay, let's say they have thought from the drawings that it will be this many square meters of wall, but actually the drawing of the, or the design of the scheme says it's a different quantity of wall they wanted to build. So the price risk of the lump sum will not on the shoulder of the contractor, because the bill is produced, they have just set the price by the side of the quantities as per their own interest, and fashionably sometimes adding a percentage of the builder's profit, and of course prelims. I'll not go there today, and all these sort of things, and send it back. So lump sum agreed, but if there is a mistake, that lies on the shoulder of the the employer, meaning the employer's architect. Okay. Now, obviously, end of the day, if there is a mistake and there is an increase in quantities, the contractor is happy, maybe if he's not too busy, but obviously the employer doesn't become happy, and they start bullying the architect and other professionals, of course. And so to avoid this, the technique started that, okay, we're not going to say what the quantities are. We will just simply say a wall, a brick wall, okay, from there to there, and as specified within the drawing, you know, and you price it. So that's the difference between a bill of quantity and a schedule of activity. So if you make a mistake in taking off the quantities from the drawings and all, it's your problem, you know. And obviously the stylish bespoke authors, they say, even if the drawing is wrong, you are the specialist, so you should have corrected it, and you should have taken that into consideration before you have priced. So that risk, given the mistakes, the drawing is also on your shoulder. There's no harm, you know, as I call it, kill them all and come back alone type attitude. But by the end of the day, you'll know where my choice lies. So I think you started feeling or developing a feeling where my choice is. So if you think you want to have a reasonable outcome and not fighting in the contract, you know, you better, ideally speaking, have a bill of quantity And sometimes it's common to ask the contractor to do the quantity takeoff and be responsible for that, and inform the architect or whoever is administering the tender or procuring the scheme to let them know. Now, target contracts, option C and D, again, are just slightly different variant. There's a target given that this much, if you can achieve it within this period, you get a bonus. That's it, nothing else. It's just like, setting reward, or sometimes, as you say, pain and gain share. If you fail to meet the budgeted cost, and if you don't have a proper justification, you then share some of it with the employer. Again, the same rule applies. It could be with an activity schedule and bill of quantity. And then, of course, the cost reimbursable contract. The contractors love them because you just have a rate sheet and cost component sheet, and you end of the month you produce that this much I've done. Traditional ICE contracts, also like the day work contracts, as we sometimes used to say, are of that type. Okay, so these are the different types of contract variants we have in NEC. What's the general structure? We have 9 core clauses. I don't have the time to describe them today, but 9 core clauses, and then of course we have the works information section separately added to it, which is, of course, and then we have the optional clauses as well. So core clauses, optional clauses, and then the section where the works scope is described, which is called works information and all. And definition of change. Well, anything if changed from what is in the contract is, of course, a change. And the method to deal with is something called compensation event. That will be in the heart of our discussion over the next 12 months. So today it's not the time to discuss about it. Now, how dealt with? Okay. Now, JCT contract suit, the current one, will have a main project type contract. I'm not going to deal with that. The secondary, the next coming list is, of course, the standard building contract with or without quantities. It's just as the bill of quantity or the activity schedule type thing, as I have discussed, and as I would start you to keep in your mind, oh, I'm more familiar with JCT, you see. NEC is not my cup of tea. Why? You were talking about essentially the same thing, isn't it? The price terms, be it A and B and priced and bill of quantity, the activity schedule, or it's with what? With price option A or B, and with or without quantities, meaning either there is a bill of quantity added or an activity schedule added. Just say the same English thing 2 different ways. It doesn't change anything else that much. There might be some finer changes here and there in detail, but more or less it's the same thing, okay? And then we have a variety these days getting popular in England as well, which is, as I discussed at length earlier, that SMM, NRM didn't allow you to have a scheme tendered before it reaches a certain point, tender stage drawings, as we call it sometimes, it reaches that point, but it doesn't stop anyone to tender it if the contractor, because this is a private deal anyway, to contractor come on board early. And the method that has been used is called design and build. Remember, it's not a turnkey like USA or other jurisdiction. In turnkey, the employer just doesn't know anything. I want a building of these many square meters, end off, with very high quality and which is of quality similar to other buildings in the area, end off. No, it's not that. You can't do that. But at least you can bring in somebody as a contractor when it's more or less sure what you are trying to achieve, and that's design and build. Okay, and if it's a design and build, obviously you don't, or you cannot handle it through activity schedule or through a bill of quantity. What you then need is employers' requirements. Okay, and so you sub-package the items with different requirements and specifications, and then rest you allow it to develop by the contractor up to the workable level, and construct and deliver the project. Again, how is the contract deal with changes? There are procedures inbuilt, and it's not called compensation event. It's a program. Sorry, it's a program and a variation and architects or contract administrators instructions. These three elements come into show to handle the changes. What is a change? Change is a change. You know, why do we need to know even what is a change? There might be a change in the employer. The contractor might say, F off, I'm no more interested, I'm going off. And I've got a mate, Mohammed Haq, who's going to do the rest. He's going to come in, so the contractor may change. If the employer is happy, you know, he can take Mohammed Haq on board. Well, the site may change. Okay, the architect may change, the administrator may change. If they're a named party into the contract, that's also a change. Okay, the specification may change. When I refer to the word specification or works information in NEC, it involves the built space or the output of the works. It may involve the input of the works. It may involve a method of the works. It may involve some goods to be used in the process. It may involve some services to be used in a process. It may involve compliance with some standards in question. So many things might change. Now, I have a very stupid way of conclusion. Well, I'm running out of time today, but I will definitely say this, even if I run a few minutes more, that and I will show you how to do this later on, do find out through a tracker in Excel spreadsheet, if possible, what is the obligation on the day you have signed or agreed the contract, okay? And keep that as a tracker list. Anything you sense is not what you thought you have included on the day zero, as I call it, the day the contract is either signed, executed, or agreed, that's a change. And remember, a common law, a change is a breach. A change is a breach. And it's only because the parties felt that it's inevitable in construction contract that changes are to be made. They included in all their models how they're going to handle the changes of the obligations as defined within their contracts. Better that, or those sections are, or better the people who are dealing with it understand it, easier it becomes. And that's where the importance come. And of course, the cast and the character, the last thing on this schedule today is a construction contract. If we look at it as a storyline or as a drama, the cast and the characters are Mr. Employer or the client. Once he signs the contract, he's Mr. Nobody. We'll see why. They pocket the budget, the site. These are the settings. No matter how seriously you want more money, you won't if there isn't that money available in the pocket of the employer and the budget of the architect, okay? And the site is the site where you are doing the works. And of course, this is a bi-party contract with the contractor and the employer, but still the architect, the contract administrator, employer's agent, the QS, clerks of works are involved. And if it's an NEC, The project manager and the supervisor is also vital. And then comes the contractor's personnel, whoever is managing the whole project from the contractor side. Then there is site manager, then there will be QS from their end, and occasionally there'll be architects for their end as well. Normally not. We'll see why and why not. And of course, clerks of works. So these are the characters. In your track sheet, you got to have one column. I prefer to have one whole tab for them and keep them on. So that's it. I'm done.
Okay, thank you for that, Mohammed. This promises to be a very interesting series indeed. If anyone has any questions for Mo, please use the chat or Q&A facility now. Now is the time to ask. Otherwise, we will see you again soon, Mo. I believe we're back with you next Wednesday for design, negligence, and duty to warn. So that's on Wednesday at 8 a.m. So if anyone would like to book a space on that, log in for that. Drop me an email, seminars@fletcherday.co.uk. And as we said earlier, if there's a specific query you've got, Mohammed is always happy to speak to anyone via the email. So it's mohammed.hack@fletcherday.co.uk. Okay, everybody. I hope everyone has a good evening. Mohammed, thank you very much, as always, for your time. Really interesting talk. And we look forward to seeing everybody again soon. Take care.
Bye-bye.